SEC versus Ripple case outcome predictions unveiled regarding the SEC v. Ripple lawsuit. There were no new developments for investors to take into consideration on Sunday. Briefs concerning remedies are now being prepared by the SEC and Ripple. The SEC and Ripple are provided with the opportunity to argue for and against a punitive penalty through the use of remedy-related briefs. Annalisa Torres, a judge, issued a ruling in July 2023 that Ripple had offered unregistered XRP securities to institutional investors in the United States. The United States legal precedent will be utilized by Ripple to argue for a lesser punishment in light of the absence of fraud. On the other hand, the Securities and Exchange Commission (SEC) is seeking a hefty penalty as a deterrent. There is also the possibility that the decision regarding programmatic sales of XRP is an opportunity to restore credibility. Judge Torres decided that programmatic sales of XRP did not fulfill the third element of the Howey test in the findings that were handed down in July. It is important to note that the finding in Terraform Labs may have encouraged the Securities and Exchange Commission to file an appeal against the ruling in programmatic sales. Justice Rakoff has decided that Luna and TerraUSD are considered to be securities. Another factor that continues to act as a headwind for XRP is the SEC's ongoing threat to appeal the decision on programmatic sales. On the other hand, decisions related to other instances brought by the SEC against cryptocurrency companies could put an end to any intentions to appeal. Coinbase Coin filed a motion to dismiss MTD in August 2023, saying that the SEC did not have the statutory jurisdiction to regulate cryptocurrency exchanges. A ruling on the motion to dismiss is expected to be issued shortly. The allegations that Coinbase functioned as an unregistered securities exchange broker and clearing agency are the subject of the motion to dismiss filed by the Securities and Exchange Commission. A further allegation was brought against Coinbase by the Securities and Exchange Commission (SEC) for the unregistered offering and sale of securities in conjunction with its staking-as-a-service program. It is important to note that if Judge Catherine Fila granted the MTD, the courts may be able to compel the Securities and Exchange Commission (SEC) to refrain from regulating cryptocurrency exchanges through enforcement. It is also possible that it will establish a precedent for the cryptos that are listed if the SEC claims that they are securities. Legal professionals think that the SEC will settle with the SEC v. Ripple case if the judge approves the MTD following the conclusion of the briefing schedule for the SEC v. Ripple case. Judge Torres is scheduled to begin deliberating on the punishment after May 6th. It is possible that the SEC v. Ripple case could be resolved quickly if the court issues a ruling on the Coinbase MTD before May 6th. If the SEC were to reach a settlement, the possibility of appealing the decision on the programmatic sales of XRP would be eliminated. Bill Morgan, a lawyer who supports XRP, recently participated in a discussion on the X forum where he offered a wealth of information regarding the ongoing legal struggle that is taking place between Ripple Labs and the United States Securities and Exchange Commission (SEC). In addition, he addressed the concerns that were raised over the influence that a recent hearing held by Coinbase would have on the case. Regarding the Ripple vs. SEC case, an XRP attorney offers some insight. Morgan sent a message on X in which he reassured users that the most recent arbitration between Coinbase and the SEC will have a neutral impact on the Ripple litigation. He made the following statement: "This was a default judgment concerning secondary market sales of several cryptocurrencies. That did not include XRP." Additionally, Morgan provided a further explanation regarding the characteristics of default judgments, highlighting the low precedential impact of these judgments due to the absence of contested arguments and evidence. According to what he said, default judgments are judgments that are made when the other side simply fails to defend. They are not very useful as examples to follow. When consumers were questioned about the conclusion that Judge Torres made regarding the security status of XRP, Morgan directed them to pages 14 and 15 of the summary judgment opinion, which provided additional information on the portion that was labeled the XRP token. In addition, he emphasized that it is clear reasoning, and I cannot add to the clarity that the judge gave us. Concerning the possibility of appeals and the impact they could have, Morgan mentioned that the Securities and Exchange Commission (SEC) had acknowledged that XRP is not classified as a security. As an additional point of interest, he mentioned that even if the appeal is completely successful, it will only have an effect on Ripple's programmatic sales, and it will not apply to other secondary market purchases. Throughout the conversation, Morgan engaged with people, responding to complaints and providing extensive explanations to clarify intricate legal intricacies. Bill Morgan continues to provide analytical analysis and predictions regarding the future trajectory of the Ripple vs. SEC case as it continues to unfold. Coinbase vs. The Securities and Exchange Commission closed secondary cryptocurrency sales ruling precedent is rejected by President Paul Grewal, the chief legal officer of Coinbase's perspective on the most recent judgment during the ongoing legal struggle between Coinbase and the SEC. Coinbase's chief legal officer, Paul Grewal, pondered on the latest default judgment. He made the following statement. The essential thing is that the defendant did not appear. In other words, the judge has the Securities and Exchange Commission CC on one side and no one else on the other. In addition, he voiced his worries about the imbalance that occurs in such procedures, which is that the absence of the defendant results in rulings that are biased in favor of the defendant. Moreover, the chief legal officer of Coinbase emphasized that the judge relied only on arguments presented by the Securities and Exchange Commission seat, noting the judge has the SEC on one side and no one on the other. In addition to this, he pointed out that the judge did not take into account any alternative opinions such as amicus briefs or documents that contradicted each other. The argument put forth by Grewal was that default judgments do not serve as a precedent or a persuasive tool in subsequent instances. They are not worth anything as precedent or persuasion. He stated throughout the conversation, even though many crypto assets are traded on secondary markets, the Securities and Exchange Commission CC maintains that they are securities. A federal judge has issued a verdict that is considered to be a landmark decision. An additional facet has been added to the ongoing discussion on the classification of crypto assets as a result of a judgment handed down on March 1st in the SEC case against a former Coinbase employee who was accused of engaging in insider trading. Because it involves individuals rather than crypto companies themselves, the lawsuit brought about by the Securities and Exchange Commission SEC added a new layer of complication to the already unfavorable regulatory environment in the United States regarding cryptocurrencies. It was discovered that Ishan Wahi, a former employee of Coinbase, had divulged secret information to his brother Nikhil Wahi and his buddy Samir Ramani, who is still at large. On Coinbase, the defendants are accused of trading unregistered securities, notably tokens with a low level of popularity such as AMP and DDX, according to the CC's argument, by reaching a settlement with the Securities and Exchange Commission CC and the Department of Justice DOJ in the past. Wahi and his brother were able to avoid the possibility of a judge deciding the security status of the tokens. A default judgment was issued by Judge Tana Lin of the United States District Court for the Western District of Washington as a result of the addition of a new element to the complaint, which was brought about by Ramani's inability to appear in court. Every cryptocurrency asset that Ramani traded on Coinbase was deemed to be an investment contract by the court, even when it was being traded in secondary transactions. A case that was brought before the Supreme Court in 1946 and dealt with the sale of plots of citrus trees is where the Howey test was first implemented by the Securities and Exchange Commission to determine whether or not a financial instrument is a security. This test takes into consideration 4 different scenarios. In the process of establishing whether or not virtual money is genuinely securities, it continues to be a common factor. Since Bitcoin was designated as a commodity in 2015, the regulatory environment surrounding it has become more clear. However, other cryptocurrencies continue to lack a clear definition, which presents significant regulatory and legal challenges for centralized exchanges. The United States Securities and Exchange Commission has expanded its enforcement actions against cryptocurrency companies, accusing them of issuing unregistered securities or selling them.